Welcome to episode number 216 of AAA Weekly Knowledge Series. As you know, the Amendment Act 2026 was notified by Ministry of Corporate Affairs on 22nd May 2026, effective from 26th of May 2026. Most of the amendments were in fact notified, so it is effective as on today because the effective date is 26th of May. Only few are pending. So let us first of all spend some time on this, what is pending. Otherwise, in today's episode, we are discussing the major change, the major shift from imprisonment fine to penalty. We are also discussing in detail what kind of penalties the adjudicating authority would be able to impose. Earlier, adjudicating authority was not having any power to impose penalties other than Section 65, but now the adjudicating authority is empowered to impose hefty penalties. However, there is a maximum cap of 5 crore. We will discuss it in length, but then before we in fact come to the main topic of this particular episode, we would only say, only for the purpose of updates, that this creditors initiated, the 5 things which are not notified, and we will wait for these notification. The 5 things which are not notified: 1, creditors initiated insolvency resolution process. In fact, we were waiting eagerly for all of this, but probably the decisions on it will be where it would be applicable, on what creditors, on what size of the company, that is something pending. So therefore, even the regulations, draft regulations are not yet made. So therefore, this is not notified. Secondly, the group insolvency also needs a lot of other amendments and regulations. So therefore, this is also pending. The cross-border insolvency, although the section 42, section 71 or section 69, that was only enabling cross-border insolvency, but the detailing was not done. Since the detailing is pending, so this is also not notified. Similarly, the electronic portal, which was there in a new section, which was in fact proposed, section 240 capital B, that is also pending, because the electronic portal, when it would be ready, then it should be notified, not before that. Similarly, the insolvency and bankruptcy fund restructuring that was supposed to be done, that is also pending, which was supposed to come under section 224, but that section is also not notified. So this is only a little bit of update that the Amendment Act has been notified other than these 5 items. So now, Ankit, we are coming back to our main topic, which is where all this prosecution, offense, fine has actually been shifted to penalty. So we actually have various questions today in this regard. So first of all, what is the only in brief, what are those sections where it has actually been shifted from fine and imprisonment to penalty? Only very brief answer, please.
So first is with respect to 74.1, erstwhile 74.1, which has now been omitted. So here there was the provision that if there is a contravention of the moratorium by CD or its officer, then that was one, which has been shifted. 74.2 was contravention of moratorium by creditors. 74 subsection 3 was contravention of approved resolution plan. So these were all contraventions of moratorium or contraventions of approved resolution plans. Another one that has been changed is that where there was non-disclosure of disputes or repayments by operational creditors under section 76. These are the 4 sections or 2 sections, 74 and 76, where the fine or prosecution, fine or imprisonment has been replaced by penalties. Also, these sections 74 and 76, the prosecution or fine could have been taken up by special court only, because they were given exclusive power under the code to that these have to be taken care of by the special court. But the penalty now will be taken up by the adjudicating authority. In case of non-disclosure of dispute or repayment by the OC, the adjudicating authority can do that on its own without any application. But in case of 74, violation of contravention of moratorium by the CD, officer, creditors, or by an approved resolution plan, adjudicating authority can act on levying a penalty on the application of IBBI or the central government.
Yes, Ankit. So I think this is very correct. One, I would just only for the purpose of like kind of further clarification. So only section 65 and section 64A. These are the two sections where the adjudicating authority can impose penalty and suo motu at its own action. However, in the case of all other sections, the penalty can only be levied by adjudicating authority in case an application is filed by IBBI or any central government authorized person. So this is a major change. Earlier, the prosecution was also based on the application by IBBI, but that was to special court. And now the penalty is also based on the application by IBBI, but it is by adjudicating authority. Major change, but I would also immediately, while Ankit has actually given an answer to what all changes have happened, I will also say that what all offenses, what all fines, what all imprisonments are still retained, which has not been changed and not been omitted. So first I will say section 68 is retained, which is regarding concealment or fraudulent removal of property by the officer of the company. And the second is the section 69, which is regarding transactions defrauding creditors, and then is section 70 subsection 1 regarding misconduct during CIRP, like bribery or false statements, and then section 70 subsection 2 regarding misconduct by RP IRP. So that is still continuing. The RP can still face the imprisonment or fine. And then section 71, falsification of books of the CD, that is also retained. Section 72, willful and material omission from statements. Then section 73, false representations to creditors, and these are sections which are still retained. So when these are retained, so that's something which is very clear, that the only there are four there are four, in fact, clauses or sections where now the authority is with the adjudicating authority. And the purpose, I would only say the purpose of these amendments in very brief, I would say that now earlier, in fact, when it was a matter with special court, that was in fact too slow, and the results have not been seen so far in the last 10 years. Similarly, in case we see in detail, we will actually discuss with that, wherever the powers has been given to adjudicating authority, those matters are otherwise also coming to NCLT for adjudication. So therefore, now along with the adjudication, in case they find that there is something which is deliberate, that actually cannot even be penalized also. So very clearly, this kind of now whatever we actually
so I think just to confirm what you're saying, so the idea is that violation of moratorium comes to the attention of the NCLT because the RP, other applicants would bring that to the attention of the adjudicating authority first, and this parallel process that any contravention of moratorium was something for which adjudicating authority was not able to do anything. So now what will happen is that in case, let's say, moratorium is being violated by the creditors or the CD, or a resolution plan is being violated. In that case, now the RP or any other person can approach IBBI, file a complaint. IBBI can then, after pursuing the complaint, go to adjudicating authority and say that this is the penalty that should be levied on this person because they are violating the moratorium or the resolution plan. So the entire action will happen at NCLT. It will not happen in two different courts. Similarly, when frivolous applications were happening from the operational creditors side, NCLT was not able to do anything earlier. Now, in case there is a concealment of payment or concealment of the dues, then that is again something that the NCLT will can take up or can take care of during the proceedings itself.
So now, Ankit, we need to touch base. What are the details of those sections which are omitted for the purpose of fine or prosecution? Now, all those things which will not be considered as offenses. So one is the section 74(1), which is, and section 74 subsection 2, and then section 74 subsection 3.
Right.
So can you provide little detail of what all these sections are?
Sure. So 74.1 always talked about how the CD or the officer contravening section 14 needs to kind of punished, and mens rea was of course an important element here. Similarly, 74.2 was with respect to creditors contravening section 14. Again, mens rea was required to be taken care of. And then 74.3 was about any bound person contravening any approved resolution plan under section 31. So that would effectively mean whether it is bound to creditors or the RP or the resolution applicant. So whoever was bound by the resolution applicant, if he was contravening anything. So these are the three parts or subparts of 74.1, 2 and 3, which have now been changed or transformed into 67B and 67C.
So, Ankit, very correctly, in case we see something common thread into this section, so the common thread is that this section is applicable to creditors, most of it. So, the feedback to IBBI was that once we talk about the creditors, so the creditors, and then secondly, we talk about the fine and imprisonment. Now, when we talk about the creditors under Section 7, it can be institutional creditors, it can be State Bank of India, Bank of Baroda, or any other institution. Now, if there is any such proceedings under Section 74, then who would be paying fine and who would be imprisoned? Because see, as far as these institutions are concerned, there are collective decisions. So, looking into this practical difficulty, looking into this feedback from the creditors, so all those offences where the fine and imprisonment was proposed for was existing for the creditors, those has actually been converted into a penalty now, because the penalty can be paid by the institution. However, the individuals who are working for the cases, they would not be under any kind of risk. So this is the de-risking, decriminalization of the creditor's role under IBC. There is no section now under the IBC where the fine or the imprisonment would be applicable to creditors. There is no section. So what I'm trying, see, it actually took a lot of time by our team and between both of us. We spent a lot of time to find out, after this amendment, there is no section where any kind of fine or imprisonment would be applicable to creditors, because section 71, 74, subsection 1, 2, 3 is completely omitted, and it is converted into section 67B, subsection 1, 2, 3. Secondly, in this prosecution and fine or any kind of offences, the mens rea is a requirement. Now, the mens rea is the knowingly or willingly, that somebody has done this knowingly or willingly. In the cases of institutional decisions, it is very difficult to prove knowingly and willingly. So this is also one of the reasons why this section is omitted and it is converted into a penalty. Because for penalty, it would only be seen whether there is a non-compliance or not. If there is a non-compliance, if there is an infringement, then the mens rea may not be applicable and the penalty would be levied. So this is, Ankit, like, what do you say about this? I think this is what is a common thread between all this amendment, including section, the other one, which is but basically there is no section now.
I think my understanding is that there was a synergy for NCLT to take these up. Also, there was a requirement to decriminalize these parts which are affecting creditors. So I think both these combined have been the thought process, because there is a lot of synergy that NCLT is dealing with an application by an operational creditor. It finds that no, this is vexatious application and it wants to kind of levy a penalty then and there. So that becomes a reason for the operational creditors not to file an application like that before NCLT. Otherwise, they never used to see the day when the special court would penalize them or rather charge a fee or fine on them. That never used to happen because that used to be such a big process.
But now it would be, in fact, more riskier for the institution, because the penalty can be imposed by adjudicating authority. And it is also the de-risking the humans who are working, the employees of the institution. It basically de-risking for them. Now, see, now coming to section 235 capital A. So this is also a very important amendment, because see, in case we see the existing section 235 capital A, and I will be reading for the purpose of our audience. The original section says, if any person contravenes any of the provisions of this code or the rules or regulation made thereunder for which no penalty or punishment is provided in this code, such person shall be punishable with a fine which shall not be less than 1 lakh rupee, but which may extend to 2 crores rupees. But when in the first line, it is mentioned where no penalty or punishment is provided in the code. But in the second line, such person shall be punishable with fine. So whenever a word fine is used, that actually means it is an offense. That actually means it is a criminal proceedings. So in this particular case, in one of the case, and that is probably the case of a Writer Business Services Private Limited versus Mr. Ashutosh Agrawal, the RP, and he was the RP of the company called Cox and Kings Limited. NCLT decided in this case, and NCLT held that the fine under section 235 capital A of the IBC, being punishment for an offence, can be imposed only by special court under section 236 and not by NCLT in CIRP proceedings, and set aside the order of the adjudicating authority which imposed 20 lakhs penalty. Now the fine is a criminal punishment. Only the special court has the jurisdiction. The Amendment Act 2026 in fact overrides this by converting it to penalty imposable by adjudicating authority. Now this is the old one. Now Ankit, what is the new section?
So the new one now says that if a person has contravened any provisions of this act or any rules or regulations made thereunder, so please note that it is not only limited to the provisions of this code, it is also with respect to rules or regulations. The adjudicating authority may, on an application by board or central government or authorized person, impose upon such person a penalty which shall not be less than 1 lakh rupees for each day during which the contravention continues, but which may extend up to 3 times of the loss caused or 3 times the amount of unlawful gain. And it says that anywhere wherever this is cannot be computed, it will not be more than 5 crores of penalty. So that's what it says, that provided further that the adjudicating authority may, for sufficient cause recorded in writing, impose a penalty less than 1 lakh rupees per day. So the penalty here is per day, because anything that is holding up any process under this law can now be taken up under this 235A. So let's say example 19.2. The directors are not giving the access to books of accounts. Now NCLT can say that okay, the CRP has initiated or has been initiated on this date. You have not been complying, so we are under this new section asking you to pay a penalty of 1 lakh rupees per day of delay.
So that means that it's applicable to even section 19 subsection 2
Yes.
contravention.
Because
so
that
let us
is
read it again. If a person has contravened any provisions of this code or the rules or regulations made thereunder, the adjudicating authority may, on application made by the board or the Senate. But here also, the application would be submitted by IBBI only. But this section 235 capital A is only possible to invoke if the application is by IBBI or central government or authorized person. Authorized person presently it is only IBBI. So then only it will be possible. Suo motu, if there is any contravention, then the adjudicating authority can impose penalty only under section 65. There is only one section, that section 65, where the adjudicating authority is not required to ask or not required an application from IBBI. In case we see this section 65, in fact, there are not many cases on section 65. Now, section 65 is the NCLT's penalty imposing power. So, in fact, the section 65 is penalty for fraudulent or malicious initiation. Section 65(1) I will read for the ready reference of our audience. If any person initiates the insolvency resolution process, liquidation, voluntary liquidation, or pre-packaged insolvency fraudulently or with malicious intent, the adjudicating authority may impose a penalty of rupees 1 lakh to 1 crore. The adjudicating authority itself, not on the request of the IBBI, itself actually can act. This section is a civil penalty provision, no criminal prosecution, and this in fact has actually been upheld in many cases. First, it was upheld by Honorable Supreme Court in the case of Pioneer Urban Land and Infrastructure Limited versus Union of India. Second, it was upheld again in the case of Ashmeet Singh Bhatia versus Pragati Impacts India Private Limited. Then it was Acute Daily Media and Others versus Rockman Advertisement and Marketing India Limited. Then again in the case of Rakesh Arora versus Acute Daily in Unique Green Global versus Punjab National Bank. So this is the only section where the adjudicating authority can impose penalty without an application from IBBI. This is one section. I think there is a new section also, Ankit, which
That's 64A now.
That's 64A now.
64A replaces.
Tell me something about 64A, which is the new power of the adjudicating authority to impose penalty, and where it is applicable, what kind of penalty it can actually be imposed, and whether any application from IBBI is required or not. Ankit,
So
actually, let us know completely.
So 65 was earlier for fraudulent or malicious intent applications filed by operational creditors. 64A is not now for frivolous or vexatious such applications. So again here the AO, the adjudicating authority can put up a penalty on suo motu basis. So this is what 64A says. So 64 now, as it inserted, is that if any person has initiated a frivolous or vexatious proceeding before the adjudicating authority under this part, it may impose upon such person a penalty which shall not be less than 1 lakh rupees but may extend to 2 crore rupees.
So that means there are only two sections now where the adjudicating authority can impose penalty without an application from IBBI. That is one, section 65, and second is section 64A. Now, there are other sections like 67B, section 67C. In all these sections, the application is required to be submitted by IBBI. So can we, Ankit, know now, what are all these sections, which are the new sections inserted with brief details? Because we also have to touch in today's episode all the penalties which can be imposed on service providers, which is as per section 220 of the IBC. So therefore, time is a constraint, so it has to be attended briefly. What all penalties, new sections which are actually now effective from 26th of May 2026, what are all those new sections which actually are now effective?
So there's 64A for operational creditors, where the adjudicating authority can levy a penalty on their own. There's 67B, which now replaces 74. So 64B again can be triggered by IBBI, central government, or any person authorized by central government. 67C is where the civil penalty is again replacing criminal. So this is applicable for operational creditors where they have concealed in an application details about any dispute or details about any payment being made. So that is 67C. There is a new section called 183A for which is penalty for frivolous proceedings for individuals. So the summary text is that it mirrors 64A, and it says that any person who has initiated a frivolous or vexatious proceeding before the adjudicating authority under this part, it may impose upon such person a penalty which shall not be less than 1 lakh. So it is for individuals, but it is mirroring what 64A does. Then we have 235A. So that's all transformed now. So we say that because there was a judicial pronouncement that you talked about where NCLT had said that no, this is under special court provisions. So now this miscellaneous and there are a lot of powers now which come through NCLT through 235A. So I believe NCLT was deserving more teeth to take care of everyday non-cooperation issues, and 235A will actually take care of that. However, as we said, that this 235A cannot be invoked automatically by the court. It will have to be done based on an application of IBBI or central government. So that is what will be coming clear through various procedures that are discussed, and how IBBI or central government or persons authorized by them can approach AA with requests for such penalties. We can now, I believe, move on to the IBBI powers and the clarification with respect to the action against service providers. So before we continue, it is very important that all these powers, whether it was special court powers or NCLT powers that we discussed, were against creditors, corporate debtor, the ecosystem that is not coming under the direct jurisdiction of IBBI. But when it comes to service providers, those people who are recognized and paneled by IBBI, there is no power for any adjudicating authority or special court to levy any penalty or do anything against these persons. It continues to be with IBBI except for one, which is a provision which is applicable where the RP does something which is fraudulent. There is a special court power, but other than that, everything else comes under the umbrella of IBBI through the inspection and complaints route. So,
No, Ankit, you are absolutely right. Even after the amendment, there is no power with adjudicating authority to impose a fine or penalty to RP. However, in case RP files a kind of frivolous or vexatious applications, then under section 65 or under section 64A, the adjudicating authority can actually impose a fine, because it is actually not restricted to any creditor or any officer of the company. In case the RP also files any kind of application which is vexatious or frivolous, the adjudicating authority can also impose penalty on RP. However, in all other cases, the RP is covered as a service provider. So the RP can be imposed penalties by only IBBI or the monitoring committee as set up by the IBBI. Or there is one section which actually where the imprisonment is also provided, and that is within the powers of special court on an application made by the IBBI. Now, let us understand what are the changes with regard to service providers. So when we see, like, we are all the RPs, liquidator, IRPs, bankruptcy trustee, they are all service providers. In fact, in this Amendment Act 2026, there is a new definition which has been added with regard to service providers. And the service providers now covered, earlier it was like kind of service provider, now it is like enhanced. And now the registered valuer is also covered under the service provider, and also again central government notified persons. Central government notified persons may be in future, it can actually bring any kind of maybe auditor or maybe any other service provider, so that the central government will notify from time to time. And
process advisors mostly.
Process advisors.
Because I think we got this feedback a while back that process advisors are working in an insolvency process, but they work outside the jurisdiction of IBBI.
So now let us see section 220, which in fact is gives the power to IBBI or to the disciplinary committee as set up by IBBI to impose or take any disciplinary action on the service providers. And those there is a process, like first there will be an investigation and then penalty. So there can be suspension, cancellation, all this is possible. But today we are only talking about the penalty provisions, and the penalty provisions section under section 220 of the code, that is what we are going to discuss. The little bit of change is that the committee constitution has actually been now completely defined, and the penalty formula is also defined. Penalty formula is like 3 times of the loss caused by the actions of the service provider, or 3 times of the unlawful gain which actually has been earned by the service provider. Whichever is higher, that can be the amount of the penalty. And in case the loss or the gain is not quantifiable, then the maximum limit is 1 crore. And however, in all these cases, there is also disgorgement. Disgorgement and restitution is also the powers of the board now. Suppose in any case the RP has earned something or has acquired any asset out of these actions. So that is also possible, that this disgorgement order can be passed, that the whatever unlawful assets or whatever unlawful earnings, that actually also has to be disgorged to the other person who actually has incurred a loss. So these kind of orders can also be passed by the IBBI. And the amendment, in fact, is one thing very, very clearly, that the the committee composition is expanded and clarified, and the explicit right of the service providers to be heard is mentioned in the law now, and penalty cap is now mentioned between 1 crore and 2 crores depending on the different situations, like in case of unquantifiable loss or gain, then it is 1 crore, and in some other cases it is 2 crore. Disgorgement is also there, but then one very important issue is that the very important amendment is that whenever there is any order passed by IBBI disciplinary committee, that can be suspension, cancellation, penalty, that actually is appealable now before NCLT, before the appellate tribunal, and within 30 days. The appeal has to be filed within 30 days. And in case we see the comparison between the old law and the new law, I would say the first comparison that we can say, as per the old law, the committee composition would be only whole-time members of the IBBI, only one committee. Now, in the after the amendment, the chairperson plus whole-time member plus executive directors, one or more committees. In fact, in case we see the IBBI portal now, there are now 8 committees. There are 8 DCs with different compositions of chairman, whole-time members, and the EDs. Then show cause notice. There is no mention of show cause notice in section 220 before the amendment. However, in section 220 and under section 219 and 220 is the show cause notice must be referred to the disciplinary committee. Right to be heard, it was not explicitly mentioned earlier, but now it is explicitly mentioned that the opportunity of being heard must be given. Penalty cap, in the existing law it was 1 crore, in the amended law it is 2 crores. Disgorgement power, it was not with anyone, now it is held with the disciplinary committee. Restitution, disgorgement, it is with the disciplinary committee now. So when it comes to disciplinary committee, that doesn't mean that it will go to the board. Once the disciplinary committee is set up, it is constituted, then the disciplinary committee itself will do all the orders. So it is not required to go to the overall board, IBBI or big board of directors, whatever. The board means the board of directors or the chairman. So appeal right is very, very explicit now, that goes to the NCLT. So I think all these amendments are in fact mostly welcome, and penalties. So let us understand now one thing. So Ankit, can we in fact consolidate in what all cases the service provider, means the insolvency professionals who are RP, IRP, liquidator, bankruptcy trustee, what all cases, what all offenses or non-compliances the penalty can be imposed, and imprisonment also. So we need to understand the risk to all service providers and specifically to insolvency professionals.
So for insolvency professionals, I believe that I can talk about the special court implication. That's under section 70 subsection 2. So in case we look at 70 subsection 2, we have a provision which says that if an insolvency professional deliberately contravenes the provisions of this part, this shall be punishable with imprisonment for a term which may extend to 6 months, or with fine which shall not be less than 1 lakh rupees but may extend to 5 lakh rupees, or with both. This is how it says. So it says that this part is the entire coverage of coverage which is in 70 subsection 2. Then we have the new provision which we just talked about, which is applicable for all applicants for vexatious and frivolous applications. So that's 64E. That is again applicable from educating authority for resolution professionals as well. That is not restricted to anyone. It says any person. So there again, the AAA can exercise its jurisdiction. Apart from these two provisions, everything else, any non-compliance, any complaints, any investigations, non-compliance with regulations, all that comes to the jurisdiction of the disciplinary committee with IBBI.
And this is the adjudicating authority and special court. And the IBBI can, any kind of non-compliance, the IBBI means the disciplinary committee can impose penalty or can even can suspend the registration of the service provider. So this is all the risk of the service providers that we actually have discussed. And in fact, in this amended act, the IBBI has taken a lot of powers. I will just spend few minutes on the powers that has been taken by IBBI, and one that let us understand section by section. Under section 196 subsection 1, the IBBI is taken this like substantive powers like registers and regulates service providers, specifies code of conduct for insolvency professionals, IPAs, IUs, and registered valuers, promote the development and insolvency profession. So this is the main substantive powers where actually it actually can regulate these service providers. Then is the section 196 subsection 1 and the clause SA. This is a new clause which is inserted by the Amendment Act. Now this new power which IBBI has got, it says the IBBI may now specify standards of conduct for the Committee of Creditors and its members. A significant expansion of IBBI's regulatory reach beyond IPs to COC itself. That's very, very significant that IBBI has now got powers to regulate Committee of Creditors. Then is the new clause, that is section 196 subsection 2 and clause Q, that is also newly added in the Amendment Act. The delegating provisions. The IBBI may specify by regulations the procedure for imposition of penalty, manners of disciplinary committee proceedings under section 220 and recovery mechanism for penalties. That also can be, it is delegated to IBBI only. Then is section 217, that is a complaint mechanism. Any person may make a complaint to IBBI against a service provider, triggering the investigation inspection machinery. And then coming to section 218, investigation and inspection powers, IBBI may appoint an investigating authority to inspect records and investigate affairs of any IP, IPA, IU or registered valuer, means all the service providers. Then in section 219, there is an amendment. Now, post-amendment, IBBI can issue show cause notice on prima facie grounds even before investigation is complete, based on available material, a significant procedural acceleration. This is procedural acceleration because it is not necessary that IBBI will always, first of all, start inspection, investigation, and then the DC action. Again, in another clause, section under section 102, 220, there is an amendment. The IBBI constitute disciplinary committee which examines investigation report, hears the service provider, and impose penalty, suspends or cancel registration. Then is section 236, which is the criminal complaints. For retained criminal offences under section 68 to section 73, then section 75 and section 77, only IBBI or central government can file complaint before the special court. Private complaints are not maintainable. Private complaints are not maintainable. Then now, in case we see the IBBI's power to apply to NCLT for penalty. First, we have seen the IBBI's own power. Now the IBBI has got the powers to apply for penalty to adjudicating authority, that is under section 67 capital B, 67 capital C, 64 capital A and section 235 capital A. And then direct penalty imposer like section 220, and in the complaint before the special court is section 236 and again section 68 to section 73, section 75 and section 77. These are the IBBI's power to go for penalty or prosecution. And in case we have to see the powers of the NCLT to impose penalty. So the NCLT can impose penalty under section 65, under section 67A and section 235A. So these are the powers, and then again section 67B, section 67C and 64A, these are the powers of NCLT to impose penalty. So anything else, Ankit, which comes in your mind regarding penalty or fine or imprisonment?
So I think we have more clarity on NCLT levying penalties. We have more teeth with NCLT. We have a few sections which are gone for the special court jurisdiction. Of course, we have a lot of clarity on and you know the cleanup with respect to litigation or past issues with the IBBI process for disciplinary action against IPs and other service providers has all been cleaned up. So yeah, I think we have clarity in law. Of course, there is no relief or any concession for service providers, but as long as things are without disputes, life will be better for most insolvency professionals and fellow professionals.
So, just in case we have to finalize this episode today, one, we say that the workload from special court actually has been shifted to NCLT. Number two, the requirement of mens rea actually would not be required for various such offences. The fine and the prosecution is converted in some cases to penalty. The penalty cap is increased, penalty amount is also defined, and the appeal route is also defined. The speed, as we understand in the criminal cases, because knowingly and willingly, these two words are added in most of the provisions where the fine or imprisonment is provided. The knowingly and willingly word is not there in the case of penalty. It is only that yes, this has not been done, so therefore a penalty. So the mens rea is not required, so it would be faster. Then two parallel kind of authorities, one adjudicating authority and one is IBBI. So this is where we actually can say that overall the service providers would be having some more risk. The Committee of Creditors will also come under some regulations. The adjudicating authority will also have some powers, of course, on an application by IBBI. And in case of frivolous and vexatious IAs, which are being filed now by everyone in NCLT, they actually can be turned down and they can be imposed penalty, which can be huge penalty, which is 1 crore. So that is where we can actually conclude this episode. And thank you very much, and do subscribe so that you get the alert for such kind of contents.
Thank you.